iPhone, please change your name in the to identify yourself.
Hi, Rick.
Oh, hi.
Hey, Rich.
Hello.
Did you see my text with the
I
letter?
did. I did see
Okay.
it.
Okay. They added a couple more besides the 5 and 6.
Mm. But okay. Okay. So let's see.
Stop checking our journal.
Hold on. Okay. All right. I
I
think
have a
we're
sharpness level of
ready
28.
to go. Let's mute everybody. Um, okay. All right. So this is the result of agents bringing something to me that they said they asked me to teach a class on it. And to tell you the truth, they identify. Well, it was Jasmine and Christine. They identified it by the item number, and it's like, well, I don't have it memorized, so I have to look at the RPA. And once I realized what it was in the RPA, I said absolutely. And why? Because because uh, I don't know why, but suddenly this has come up a lot. I've just been dealing with it last night with an agent. So, um, what are we talking about? Let me show you what we're talking about. Hold on. I'm gonna find it now. I got too many things. Here we go. All right. So what you should be seeing is, excuse me, the RPA, and it's a section of the RPA called allocation of costs. And what we're specifically talking about is our items Q5 and Q6, government required point of sale inspections and reports, and government required uh, corrective remedial actions. Now, Christine, you said they added something else. What else did they add?
Rich, I'm driving. I'm going to be home in 5 minutes, so I'll pull it up and
Wait,
tell you.
I'll look at
It's
it. Wait, hold on.
okay.
Never mind.
It's the other um government tax. It's a tax or something. I forgot what it is right this second. And I have to say, with all the time I've been getting those kinds of things, it's all been in Orange County. I'm just curious, the agent that you had a problem, was it also in Orange County? Was it here? Because I haven't seen it here
No,
yet.
it's one of my agents. So
here. Okay.
yeah. Let me see. Oh, it's this one. Okay. So they're also including Q11 and Q15. So what's Q11 and Q15? Q11 is city tax, and Q15 private transfer tax. So private transfer tax, I always write the sellers to pay private transfer tax if applicable. And if it's not applicable, they don't have to pay it. So I don't understand why um, they would want that written out or not even written into the contract. City transfer tax. Maybe that's a result of the mansionization tax. I'm not sure why that would be. That's interesting. I If it is because of the mansionization tax, that's a lot of money. And so I wouldn't necessarily say, yeah, go ahead. Um, so, but what we're
Rich, can I just add something for the other agents
sure.
that don't know? So, for anybody that's on here, what's happening is I'm getting a lot of supplements on properties that my buyers are interested in that have how to write the winning offer as the title. Now I've seen it the exact same name several times, different brokers, companies, and they'll write out, here, blah, 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 everything that they want, whether they want a SIP and stuff. And they're saying to take these out, that they're going to counter all these four, but mostly the 5 and 6, Q5 and 6 out. And so that's why I'm asking the question, because I
Right.
keep seeing this
So
happening.
I'm
Anyway,
I'm
thank you.
sharing right now what she's talking about. This is an example that she sent me. Um, uh, she sent me an example of a letter that she receives. Tips for winning a competitive offer. Giving giving the seller's name. That's a great thing. Yeah, the APM number, great. Escrow, EMD, reduced contingency period. There you go. All good things. To help you in competing inclusion C supplement in MLS. Um, don't know what that would, but then it says items that do not apply. Q 3Q5, 3Q6, 3Q11. So they're trying to say that city taxes don't apply. I find that really hard to believe. Private taxes, okay. So, you know, if it's Orange County, here's the thing: if it's Orange County may not have a ordinance, a city ordinance about in regards to retrofitting, stuff like that. So maybe it doesn't apply, but if I were you, I would certainly do uh, do some research as to that, or have you? Well, I would actually do the research and talk to a KW agent down there, um, and say, look, do you have any? Is there anything? If you're going to do business in another area, then you need to know the area and what the local flair or the local procedure is down there. And I'm going to tell you why. Um, because the other thing that we're talking about um, is the governmental. What is it? Wait, I gotta find my contract again. The governmental required point of sale corrective remedial actions. And here is why. Because I had an agent who represented a buyer in who's the buyer in the city of Bell. The city of Bell evidently requires a pre-sale inspection and report. The seller's agent countered that out. And my agent, who is the buyer agent, went forward with the deal. Then after close of escrow, come to find out, if they had done this pre-inspection, they would have found all these corrective remedies that were tied to this property that were also that needed to be corrected, and it resulted in a lawsuit. Now, the buyer wanted a whole brand new house built for himself. Didn't get that, but he did get money, because that really is It was a legitimate problem. The agent messed up, and because everybody, yes, you have a California state real estate license. You can do business anywhere in California. Yes, because of that. But if you're going to do business outside of your known area, you need to find out what idiosyncrasies that area has. Because I've had a couple of agents say, I'm my friend up in San Francisco wants to buy this place and blah 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 blah. I say refer it out. San Francisco is crazy. Do not do business in San Francisco because they do things their own way. They have their own MLS. They don't share data. They have their own procedures. They have, it is a mess. And I wouldn't um, add the liability of doing something in an area that I'm not familiar with. Or team up with somebody up there, either refer it or team up with somebody up there who knows. Because for one thing, you're required to do an avid and all that stuff. So, doesn't release you of those obligations. So that's really important that you need to know. In that you need to know the area that you're doing business in, and how they do business. Now, in regards to governmental required point of sale inspections and reports, I'm going to show you, since we mostly do business. Where are you? Since we mostly do business in Los Angeles, well, let's go over what am I sharing here? Okay, hold on. Where are you? Where to go? Am I sharing anything? Let's see.
Yeah, we're seeing your SBSA screenshot.
Okay. Well, that really wasn't the one that I wanted, but I'll go over that. So this is in the state buyer and seller advisory. Retrofit building requirements and point of sale requirements. Buyer and seller are advised of that state and local laws may require the installation of operable smoke detectors, bracing of water heaters, and upon sale completion of a corresponding written statement of compliance that is delivered to buyer. Although a point of sale or retrofit obligation, state law may require the property to have operable carbon monoxide detection I lost my place. Devices. Additionally, some city and governmental governments may impose additional retrofit standards at the time of sale. Blah 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 blah. Then we go to broker. Recommend that buyer and seller consult with appropriate governmental agencies, inspectors, and other professionals to determine the retrofit standards of the property to the extent of the property complies with such standards and costs, if any, of compliance. Brokers do not have expertise in this area. What does that mean? That means you can't say to a buyer and seller, oh, you don't need that. That's not needed. You don't know that. You don't know definitively that we escrow may tell you that in one area it is required, in another area it's not. But that shouldn't come from you as the real estate professional. So that's what's in the state okay, in the state version. But let's see what I really wanted to share, and that is, I think it's this one. This should have, from the RPA, the allocation of costs. somebody confirm that that's what we're looking at? Because it's really tiny when I go to
Yes.
choose it. Okay, great. Thank you. So this is in the RPA. It explains what governmental requirements are: legally required installations and property improvements. Any required installation of smoke detectors and carbon monoxide, or securing of a water heater. If buyer is to pay for these items, buyer is instructed by escrow holder shall deposit funds, blah, 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 unless seller is exempt. If they're exempt, they're a surviving trustee, or they're probate. That's an exemption. Point of sale requirements. We go into that also. So these are what are required at point of sale. And what does that mean? That means prior to the close of escrow. And since we are talking about Los Angeles, in your KW addendum, thank you, I just thought of it. There is a section that says City of Los Angeles only. The number one thing on that City of Los Angeles is the report of a residential property records and pending special assessment liens. If property is residential, only applies to residential, and is located in the City of Los Angeles. Now remember, City of Los Angeles is a big city. We're talking about the greater Los Angeles area. I'm in Woodland Hills right now, and Woodland Hills is part of the City of Los Angeles. Van Nuys is part of the City of Los Angeles. Calabasas is not, it's its own. So anyways, there are different areas that of Los Angeles, but they still comprise of Los Angeles. So the seller shall pay for and deliver to buyer prior to close of escrow this report. What is this report? It's called the 9A report. And everybody thinks it's a waste of money. But I will tell you that I've had deals where I've gotten the 9A report, and on the 9A report, in regards to the sewer connection, and this was a house up in the hills, the sewer connection permit not pulled. So what does that tell my buyer? That there was never a permit to connect the sewer to the city line. The listing agent said to me and the buyers, oh, it's just a mistake after close of escrow, your buyers can go down and take care of it. It's like, oh no, we will not be doing that. Your seller needs to do that prior to close of escrow. And they needed to have the city come out. They needed to dig up where the connection was, have the city come out, confirm that it was connected, and then everything was fine. But so this report does give valuable information on it. It also gives what permits have been issued a lot of the times. So that's also beneficial. So the other part in the KW addendum regarding mandatory, and I stress mandatory, governmental retrofit items, water conservation certificate, that LADWP certificate of compliance. Now there is a place on that certificate for the agent to verify that it is true. None of you as my agents should be signing that. I don't want you to be responsible. Are you going to take liability that what it is true? No. So that needs to be done by by a retrofitter, or the seller can sign off on it. The seller wants to sign off on it, that's fine. But you as the agent should not. Also, part of it is impact, hazard glazing. We know that it's smoke and carbon monoxide detectors and the gas shutoff valve. Those are all part of a mandatory, once again, mandatory governmental retrofit item. So when these entities are being written out of a contract, and I'm going to waive, the buyer and seller have agreed to waive doing the retrofit because it's a tear down, or it's an investor that's going in there and they're just going to be, I'm sorry that there's noise behind me. There, that there's that an investor's going in and they're just going to knock it all down. And what I say to them is this: I will allow it to be waived, but it's a very short list as to how I will allow it to be waived. If it is indeed a teardown, meaning I need to see that it is a dilapidated building, it is, uninhabitable. That's the key word, uninhabitable. And it currently is not. There isn't anybody living there. Then I will agree to waive it. But short of that, if somebody is living in that property, I will not waive doing the retrofit. And why? Number one, just because I've been dealing with this in the last day, I've gotten legal counsel opinions, and this morning I was on the phone with CAR Legal, and CAR Legal had an interesting came up with an interesting perspective on this, which kind of had gone over my head, and that is, this is a governmental requirement. It is an LA municipal code ordinance. The buyer and the seller don't have the right to waive it. It's like saying that, and this is the example the attorney gave, there's a speed limit of 55 miles an hour, but I'm going to waive that. I'm going to go 70 miles an hour. They have no right to do that. So it's not their right to waive that. And I, as the broker, if somebody is living there, I need to abide by the law. So do you, because that's number one, part of your code of ethics as a realtor. It's also part of your rules and regulations as a licensed real estate agent in the state of California. The DRE does not allow you to circumvent the law. So this needs to be explained to the buyer and seller that we are under the obligation to make sure that this takes place because it is a law. Unfortunately, that's where we're at. Let's see if did I have any other things that I wanted to show? I don't think I did. Does anybody have questions about this?
I have a question.
Sure.
So I had never heard of this report before, Rich. So does escrow get us this report, or title?
Yes. Escrow gets the report.
Okay.
The 9A report is as soon as soon as you're on a listing agent, a listing appointment, you should talk to your sellers about, there is this report that is required in the city of Los Angeles called a 9A report. And it costs $78.20. Why the 20 cents? We don't know. It needs to be ordered relatively soon because the city takes their time, and we can't close without it.
Thank you.
Because it's required by before close of escrow. Now, in regards to the retrofitting, listing agents should be ordering a retrofit inspection, in the city of Los Angeles once they get into escrow. If it falls out of escrow, it's good, I think, for 6 months. Would double check with your escrow officer, but yeah, that's that. Any other questions?
One more,
Yeah,
but
you have something?
just
Sure.
with what you just said, because I didn't know that, is a retrofit inspection done? Is that something most homeowner inspections do in there, or is this an extra report?
No, this is in addition to. Part of their inspection is looking at low flow toilets, making sure that there are low flow toilets in there, that the gas shutoff valve, it has an earthquake gas shutoff valve, that there are working and properly placed smoke detectors and carbon monoxide detectors, and the water heater is braced, and finally, that if there is a sliding glass door, that it's tempered glass, and you can find out whether it's tempered glass or not, because if you look at the lower, I don't know if it's the right or left, I think it's the left-hand corner, there would be a little symbol or a little writing that says tempered glass. If that's not there, then most likely it's not tempered glass. And what happens when somebody walks through it, it shatters, and shards of glass can kill a person. They don't have to replace the door if that's the case, but what they do is they put a film on the glass, so that if somebody breaks it, it doesn't shatter and there's not shards of glass. It kind of, if you've ever seen like a car window when it's broken, it just like kind of is one piece, and and it's all cracked in one piece. And that's what this will do. Okay.
Thank you.
Rich,
Wait, hold on. Mitra has a question. How can we find out if listing that still needs a pre-sale inspection? Where was the one that I just had that there was a pre-sale? Wait, let me look at my emails. Most don't. There's very few. City of Thousand Oaks does have an inspection prior to close of escrow. What was that inspection report? This was. Oh wait, where is this? Pre-sale. Wait, hold on. Give me.
Rich, we could check with various escrow companies. They usually have lists.
They do have lists. They do have a list, but I'm trying to. I'm not sure. Inglewood has a pre-sale inspection. So
I believe Pasadena does too.
Well, Pasadena did, and then they did away with it.
It's
and
self-certified.
Then I heard that.
Yes.
Right, it is self-certified. Yes, but I had one. I had a couple in condos before it was self-certified, and they had to come in and inspect. And then I sold a residence in Pasadena, and that one was self-certified. But it goes back to that problem that had arisen with one of my agents, in that there may be things that show up, old violations that you don't know about. So I would not, I would, especially if you're representing a buyer, then I would definitely not allow the listing agent to circumvent that. The Pasadena inspection, it used to really screw up deals, because a garage that was converted, or that wasn't even built. It may have been a carport that was enclosed or something. The city of Pasadena would make, and then the city would make them undo it before close of escrow. I mean, it was a mess. So I think they've gotten a little more lenient, but who knows?
Can I riff
I
on
think,
Rich? Can I?
yeah.
So the two situations, one that I'm in now and one that happened a few years ago, that I'm just want to clarify how you want this handled. So I'm just going to use the example so that there's an understanding of it. So I sold a property that was a development property. It was tear down. It was another agent in the office representing the buyer. It had been a preschool that had those little kid toilets, and they were not low. So when the retrofit was done, it was something like $700 a pop to replace these low flow toilets. The buyer took the responsibility of that because it was going to be torn down. Are you saying that you don't want us to do that? I mean, the deal wouldn't have gone through over it because there was like 10 of them.
No, I'd say, like, in this instance, obviously, if it was a preschool, for one thing, it was being sold as a preschool.
No, it was I don't remember. I think the zoning was like 1.5. They were going to build a small lot on it. So it was all going to be torn down.
But the existing property was not a residential property, correct?
It was a house with a school
behind. A house with a school.
So the issue of the low flow toilets was in the school part, but all of it was going to be torn down. So I just want to clarify.
I probably would have allowed that to be waived because of the circumstance of where, and it wasn't being occupied presently, correct?
There was a hoarder. The seller was a hoarder, and she was living in the main house, but she wasn't living, or maybe she was living in the preschool because she couldn't live in the main house. I don't remember.
Right, maybe, yeah. I mean, I probably would have looked at it that.
Okay, so that
I'm just trying to get, because there is liability, even though, I mean, even though people sign things that they're not going to hold you liable, that doesn't suddenly release liability, doesn't give them the right to suddenly sue you. Anybody can sue anybody, even if you sign something that says, I don't hold you liable. And the hopes is that you end up settling and getting, and they end up getting something, because it's cheaper to do that than to play it through and do that. And my example, and it's funny because the lawyers that I've been talking to in the last couple of days is like, okay, so you allow this to be waived. Somebody is living in the house. It's a seller rent back. So then after close of escrow, something happens. There's a fire or a heater where there's carbon monoxide. People are injured or killed. Because I've had one attorney say to me, well, what's really the damages? How much in that scenario, it's a life. So you've got to, unfortunately, this is what I have to think about. And so that's where I'm coming from, protecting you as the agent and the brokerage, that we don't get into these situations. So, so I'm sorry, Charlotte, I interrupted you. You had another example.
Yeah,
Go
I
ahead.
understand that, and that makes sense. So then I have another thing to riff on your Pasadena thing. So I have one coming up right now, and I've talked to a couple of agents that I've worked with out there, because you do the pre-sale cert. And for example, if you answer the question, is there any unpermitted space on the pre-sale cert, it triggers the inspection. So I've got an illegally converted garage in this listing. They're very, very nervous about it. They did not plan on selling the house, but now they're selling the house. What I have been told by several local Pasadena agents, I work out there a little bit, but these are people that work out there all the time, is you disclose it on the MLS like you would in anything. We would disclose unpermitted guest house in LA as well. And you say buyer to assume responsibility in the MLS. And then the city inspector comes out and they say, oh, we don't like this or whatever. And the buyer assumes the responsibility, because they could feasibly go through the process of permitting it as an ADU or pool house or whatever. Or they may want to turn it back into a garage. I mean, it's not really up to the seller to make that determination of what the future use is for that buyer.
Right.
They would find what's there useful. So are you comfortable with that type of?
Absolutely. You're right, because you're disclosing it in the MLS that it's unpermitted, and
So
that should, and that should any correction or, I'm sorry, I can't remember what the wording was, but whatever the wording was, is that the buyer is now assuming the responsibility for any correction, and as long as they've been made aware of that and are fine with that, and I would assume that in the offer that's in there somewhere. Is it?
Well, I would make sure that, it's not even
Right.
but I'll make sure, of course, that it's
No, yeah, as long as it's in the
sure
offer
that
yes. Yeah, that buyer, should the city of Pasadena require any corrective actions regarding the unpermitted garage, buyer assumes responsibility. Then you've covered yourself. As long as, remember, what's in the MLS that you don't put in the contract isn't enforceable. Like,
no, I understand that.
So,
The thing about Pasadena in particular is, unlike LA, where you can order the 9A when you get the listing appointment, you can't do pre-sale cert in Pasadena until you have the name of a buyer. So you have to disclose it up front and then hope for the best.
Right. No, I get it. No. Yeah. No, I'm fine. I'm fine with that.
Okay.
Richard,
thank you.
I have a
Great.
question.
Thanks. Sure.
In that scenario, if she is to receive an offer from a buyer, that Q5 and Q6, should that indicate that the buyer will pay for those things? If she's, as the listing agent, going to be receiving an offer and they're going to assume the.
Yes.
Yes, absolutely. In
Okay.
regards to the corrective, yes. Yeah.
Okay. Okay, perfect.
Any other questions?
Rich, I'm just gonna go back to the 5 and 6, but
Sure.
the other 10 and 11, which was county transfer and city transfer, I get that. That was the only one that I've seen that had that on it before, the winning offer.
Right. But what they're saying is it doesn't apply, and that's what I don't understand. Is does this particular town in Orange County have no city tax?
No.
That's the only way that would apply.
I know.
Because they're saying they don't write them in because they don't apply, and it'll be countered out.
Right. Okay.
So that's where I'm confused about that. So I would question that. Yeah.
Okay. And
So
then
go ahead. I'm sorry.
that's okay. But the 5 and 6, like in that, you know, you can Google, go online and see what are all the positives, you know, the negatives of saying buyer, you know, pay or seller pay, right? But how, when they're saying they're taking it out, you know, the buyer, just say that situation. So the buyer wants to keep it like it is, but now the city's going to come in or whatever, they have to do a correction or something. It could be hundreds of thousands of dollars. I mean, it depends on what it is. I mean, we don't know what it is. So
Right.
in arguments, you know, I can go on and Google and see arguments on both sides, but I see why it would take it out. I've never had anybody else take it out, but I have seen that written there. How else would you explain this, or have, like, how are we protecting, say we're on the buyer side, how are we protecting our buyer if the agent's taking that out?
You're not. That's the point.
No,
You're
I know
not
that's
protecting the buyer. Right. Yeah. So,
If you're
I
talking
mean,
about the example that I just gave, the city will come in and say whatever it is they're gonna say. That's part of the inspection process. So you'd be giving that to the buyer. But you don't
right.
know.
And then they have the option of accepting that or backing out because
Yeah, I mean, that's the risk that my sellers are
right.
taking, in that they can't get that inspection prior to doing their pre-sale cert and having the buyer's name on it. So they don't really know what the city's gonna request, or if the city's even gonna care.
But that's kind of, that's what the pre-list, what you're saying, but I'm not talking about that. Like Orange County doesn't have that. And where I've been, and this one happened to be in Costa Mesa, and I've sold 5 properties there. I've never had anybody do that before, Rich. So that's why I'm saying I'm seeing it now.
Right.
So, you know, the protection is, well, besides, okay, government, you know, doing any of that, I guess we would get the retro. If you wanted to get it out there, you would have it in, okay. Just so they're knowing.
But okay, say in your example regarding Orange County, and they want it countered out. Well, but you want it countered in, and so I mean you want it in. So why not make it the responsibility of the buyer? And then just like in any instance, if there's something, they're getting a report, and if there's something in that report they don't like, then they have the right, unless they've weighed their contingencies, they have the right to back out because of it.
Right. Okay.
Just like in a termite report. I mean, you know, I tell buyers, pay the $100 for the, when I was doing it, it was $100. I don't know if it's still $100. Pay the $100 for the termite report, and you know, and then, you know, if you don't like it, then you know you can get out of it.
Right. Okay. I was just going to bring an example because you were bringing about the retrofit to people like you had.
Sure.
I had Woodland Hills, and it pretty much was someone was not living there because they were in a nursing home, and the person that was buying it was going to be remodeling it and pulling out doing everything. So, but you still made me get it for the sliding glass doors to get the glaze, but it was very inexpensive. And just for everybody else, your reason was very well thought out, because it was that they're going to have contractors in there. And if somebody's taking that glass out and gets hurt, you know, there we have an issue. So that was why we did it. And it was, once I explained it to my seller, they're like, oh, we get it. And it wasn't very expensive, $500 or something.
No, I think it's like $100. Yeah. I don't think it's other place. So, okay. Any other questions? Because that's basically what this was about. You know, look, I'm trying to protect everybody here. So, including the buyers and the sellers. Believe me, I've been on the other side of lawsuits for I don't know how long. And it always ends in costing. So if we can avoid getting there to begin with, because people are suing just because they know it's a nuisance to sue, and that they know just to make it go away, they'll get something. I mean, it's California, and unfortunately, that's the way it is here. And I've had agents who have been in the business for years and years and years, never had a claim, never, and now have had a claim, and they're freaking out. And it's like, or this is ridiculous. I'm gonna fight it. I'm gonna fight it to the end. It's like, but you need to understand that when you're fighting it to the end, number one, that costs money. So it probably isn't worth that fight, because at some point it's out of your hands. And remember, in your ICA agreement, there's a clause in there that says the carrier and the broker have the right to settle. So at some point, we're going to say, I know that I know it's the principle. I know it's the principle, but sometimes principle has to take a sidebar, and we just have to get out of this. And I know nobody likes to hear it, but and I'm the one who has to deliver that a lot of the times, and I don't like delivering it, but that's just the way it is, unfortunately, in this state. And I've seen it time and time again. I mean, I'm in hours, half day mediation, sessions, and that are ridiculous. So I'm just trying to avoid that. And so I'm not unreasonable, but you have to see where I'm coming from, and that that there are times that I have to say, this is the policy, and unfortunately, please, if you're coming up against something, and this is an issue that I have in 3 days, and I escrow needs to get a waiver for me because we didn't do a retrofitting. Where were you on day 5 when you knew that this was going to happen? It's like, you need to come to me before you're 2 days from close and say, here's the scenario. This is, will you waive this? Don't ask me with 2 days left where I'm feeling like a jerk and saying, no, you've got to get it done. We can't close without it. So, help me, help you. I don't know I can't remember what that's from. It's from
Jerry
some movie.
Maguire.
So Jerry Maguire. It just, as you were saying it came to me. Yes, help me, help you. Okay, so yeah. Anything else?
Yeah, quick
Anybody
question.
else?
Quick
Sure.
question. We were primarily discussing the city of Los Angeles, and we touched on Pasadena a bit. My question is this: for our files, if we are representing a buyer and it's not the city of Los Angeles, for example, I'm in an escrow in Diamond Bar, but the listing agent hasn't done a retrofit inspection and then may not even plan to, for our file, because again, that's not city of Los Angeles, for our file to be complete, what would you like to see?
If your buyer is handed a report, that needs to go in that file.
Yeah, but what if
so? Yeah,
what I'm asking, what if the listing agent and the seller do not have any kind of report to verify that everything's in compliance? What would you like to see?
Well, but I don't think it's required in Diamond Bar. Is it required in Diamond Bar?
So you're saying
I think it is.
For our file to close with our office, it's okay not to have any kind of
if it's not required, absolutely. If it's not required, you're an escrow. I'm assuming, Michael, that you're representing the buyer.
Correct.
Right. Okay. So you go to Lisa or Sylvia and say, hey, does Diamond Bar require retrofitting? They say no. And so then when it comes to compliance, if they're giving you a hassle because there's no retrofit report, say, write on a piece of paper in big letters, retrofit not required in the city of Diamond Bar. Hand it over to them, let them upload it. The file is complete.
So then in the case of the worst case scenario, if a year from now, somebody were to pass away because a smoke detector wasn't installed or carbon monoxide detector, we would not have any liability as a result of that?
No, because it wasn't a requirement
Okay.
that it be.
Great.
Now, smoke detectors are required by state law, but and if there was an inspection, there's it should be noted that if it's noted on an if it's noted on an inspection report and you're representing the buyer, if it's noted on an inspection report that there are no smoke detectors, no carbon monoxide detectors, if I were you, I would number one be asking for the seller to install them.
Mm-hmm.
If they refuse, they refuse. But I would be sending something to your buyer in writing saying, this is a safety issue. Carbon monoxide detectors and smoke detectors need to be installed. Please, be aware, just so that you've informed them. And then if something happens later down the line, it's like, well, look, I informed you. So,
Okay. What if the seller does do the installation? Can the listing agent take some photographs and send the photographs as proof?
Sure. Sure.
Great.
Yeah. Okay.
I mean, generally, if there's a loan and there's an appraisal, the appraiser is
right.
Yeah, the building.
You're gonna need the carbon monoxide. Sure. I mean, I as a listing agent, I would have 5-6 carbon monoxide detectors in my car.
Yeah.
And if there, before the appraiser got there, I'd install those suckers, or I would install them before they got there.
Right.
So that, number one, now it's in the contract. If an appraiser has to come back for a reinspection because something wasn't there, then they're going to charge the seller. So it helps your seller. So,
this particular case, the building qualifies for a appraisal waiver, so there won't even be an appraisal that's going to happen.
No, they won't even be. Yeah. Okay.
Yeah, but I think just like you said, if the listing agent takes a photograph,
sure,
that should be fun. Okay, good. Good to know.
Great. Anything else? Anybody?
Super good class.
Bueller? All right. Okay. So I want to point out that this was the result of agents coming to me, and Charlotte, I did get your list, coming to me and saying to me, hey, I'd like you to do a class on this. And I did it because for one, it was timely, and this is a little pet peeve of mine. So if you have suggestions, I'm open to suggestions. Don't if I don't take your suggestions, don't feel bad. It may be that I have something planned later down the line or whatever, but I'm always open to suggestions because I don't like repeating myself. Previous brokers at these offices would just do the same 2 classes, alternate them every month. And I don't think that that's informative, especially since we're recording these and you can go and refer back to them. So anyways, I'm not sure that there will be classes. I know there won't be a class the first set in May, because next week I'm in Sacramento for CAR meetings, then I come back for a few days, and then I go on to DC. I think there will be a class at the end of the month. I'll have to look, but be on the lookout for emails from me regarding that. Okay. Thank you so much, everybody, for coming, and good questions, good discussion. All right. Take care.
So fast. Thank you. Thank you.